Council for County Assembly, you may proceed to make a closing statement for not more than 60 minutes.
Thank you very kindly, Mr. Speaker, sir. We'll have Mr. Muriuki taking the first 20 minutes.
Mr. Speaker, my name is Eric Muriuki. I will take the first 20 minutes of our closing argument. Mr. Speaker, sir, honorable members of the Senate, when the story of devolution in Kenya is told or is written, the members of the 3rd County Assembly of Meru will be remembered fondly as champions of devolution who, without compromise or favor, exercise their oversight role, champion for accountability, transparency, and good governance by holding the person accused before you to account for every transgression. These members of the 3rd County Assembly have performed their oversight duty even when it was inconvenient to do so, even when it was not fashionable, despite several and serious challenges, including threats to their lives and their families, as you heard the testimony of the attempted torching of the Assembly. Mr. Speaker, sir, the MCAs, the elected representatives of Meru County, have told this honorable House time and time again that there is a problem in Meru. In 2022, the MCAs were before this House when the governor, barely a few months after being sworn in, had opened war fronts against members of the county assembly through vilification campaigns, against the church, against elected leaders in the county. And back then, during the first impeachment process, the governor was offered invaluable pieces of advice by the members of this House who were in the select committee that was investigating the matter. And indeed, the governor vowed to become the foremost peacemaker in Meru. This vow was short-lived, and in 2023, the governor found herself again before this House, answering to other charges, having opened more war fronts, including now her own deputy, by encouraging and condoning junior officers to undermine and insult that deputy governor. She was at war with the members of parliament from Meru. She was at war with the council of elders, with the senator of Meru, and other leaders, as the record of this House will reflect. Now, the governor has fallen out with her own secretary of the County Public Service Board. And perhaps inspired by getting away with her actions twice, the governor has now become so bold in her violations of the law to the extent that she has personally, under her own signature, purported to dismiss the secretary of the County Public Service Board in clear and gross violation of sections 58 and 59 of the County Government Act and in usurpation of the powers of the Assembly. Although the governor terms what she did as revocation, she has failed, when put to task, to point to any provision of the law that allows this thing called revocation. Mr. Speaker, sir, for purposes of putting the record straight in this House, once a member of the Public Service Board, or the County Public Service Board, is appointed in accordance with the County Government Act, Section 58, the process of removing that member is as is provided in Section 58(5) of the County Government Act, and upon the grounds that are set out in Article 251 of the Constitution. And despite being advised by her own chairperson of the County Public Service Board, the governor proceeded to purport to revoke the appointment of Ms. Virginia Kawira Mereti, who is now only in office pursuant to a court order. Mr. Speaker, sir, honorable senators, surely it cannot be, or at least it cannot honestly be, that everybody else is a problem in Meru. It cannot be that it is the MCAs that are the problem. It cannot be that it is the church which is a problem. It cannot be that it is the elected leaders that are the problem. It cannot be that it is her own deputy that is a problem, and now the County Public Service Board. Mr. Speaker, sir, during previous proceedings before this House, the governor blamed her misdeeds or whatever went wrong in the county on two officers, the chief of staff and the county secretary, in her famously infamous defense of "it wasn't me." However, when the county assembly made recommendations that the governor institutes disciplinary measures, including dismissal, against these officers that she blamed for things going wrong in the county, she refused to implement this recommendation. A fair-minded and reasonable person, honorable senators, must therefore conclude that the governor has been acting through those officers, or that they have been violating the law and the constitution with her blessing and under her patronage. On one hand, the governor tells you in her defense that the violations of the law she is being accused of are occasioned by others. It is the county secretary, it is the chief of staff, and that those others should be called to answer those violations. But then, on the other hand, the governor proceeds to tell you that the county assembly has no powers to recommend that the governor should take action against these very officers that she blames for those violations. Surely, honorable senators, the governor cannot have it both ways. Article 185(3) of the Constitution of Kenya empowers the county assembly to exercise oversight over the county executive. And one of the measures of oversight is to recommend removal from office of these officers that the governor herself has previously pointed at and blamed for violations of the law. Mr. Speaker, sir, honorable senators, when you retire to make your determination, remember, it is not the MCA's word against the governor's. No, it is the governor's own words and actions against the legal and constitutional requirements of good governance and integrity. Mr. Speaker, sir, honorable senators, you have heard in videos number 1A of the County Assembly and 1B, the governor, in her own words, tell a dangerous lie that 86 million shillings was collected for the burial of the deceased sniper, a fact she very well knew to be false. And when put to task to prove those statements, she has failed. In cross-examination, the governor states that the only evidence that she has of 86 million is a video, which video has not even been shown to this House. Mr. Speaker, sir, you heard the young widow that stood here, Irene, tell you that as a result of the governor's lies, she has not only been ostracized by the community, but has also become a target because people think she has 86 million that she is holding on to. Honorable senators, let me remind you that the evidence of the young widow was unchallenged. Not a single question was put to her in cross-examination by the governor, and the inference here must be that she was telling the truth, the whole truth, and nothing but the truth, to the extent that her testimony could not be challenged. Honorable Senators, words spoken by leaders mean something, or at least they ought to. Words spoken by leaders have real consequences. A leader of the stature of a governor telling such a lie to the public has led to such disastrous consequences, as you heard the witness testify here, that she can't even live in a matrimonial home. Honorable Senators, that cannot be taken as anything else other than gross misconduct. Article 73 of the Constitution of Kenya does not leave any room for a public officer to make such misleading utterances to the public, endangering the lives of others and bringing dishonor and disrepute to the office that she occupies. And such misleading claims are also in gross violation of Section 19 of the Public Officer Ethics Act. Mr. Speaker, sir, honorable senators, you heard the governor in cross-examination admit here that her conduct was insensitive to the family. This pattern of lying to the public that the governor engaged in, she did so while paying full salary and benefits to one of the persons accused of murder of Sniper. Christas Kiambi Manyara is a communications officer in the office of the governor. It is not in doubt that he was charged on the 29th of February, 2024, and it is not in doubt that he continued to receive his full salary and benefits, as evidenced by the payslips produced in, among others, page 392 and 393 of Volume 2 of the County Assembly documents. Mr. Speaker, sir, in that pattern of lying, the governor says in a video that she does not know this person, who is a main suspect called Vincent Mureithi. However, Mr. Speaker, sir, documents have proven that this person was employed as a deputy director of the governor's press, and that one of his referees, in the governor's own words, is the governor's sister, who is also her PA. You will find this person's letters of appointment in pages 445 to 452 of Volume 2. This is a person that the governor denied having any knowledge of. Honorable senators, it cannot be a coincidence that this outspoken activist who criticized the governor was murdered just a few weeks after the second impeachment motion. It cannot be a coincidence that the people accused and charged are so close to the governor by her own admission. Honorable senators, moving on, as a result of the governor's breach of the law and court orders, the county of Meru has suffered financial losses, including being slapped with costs of 3 million shillings, and this house can confirm the same from the decree of the court produced in pages 162 and 163 of Volume 2. Honorable senators, the Auditor General's report identifies that the management of Meru County is headed by the governor. And this is in line with Article 179(4), which identifies the governor as the chief executive of the county assembly. And the Auditor General's report flags breaches of the law by the management by including other things, irregular payments, excessive wage bill, use of the manual payroll, which compromises transparency and accountability, and this can be confirmed from pages 344 to 347 of our volume 2. Honorable Senators, the use of the manual payroll, according to the Auditor General, has led to a loss of 102.9 million. Honorable Senators, the Governor has refused or failed to appoint chairpersons of various boards in Meru County, and therefore these boards cannot be said to be legally constituted. Even when the Governor purportedly forwarded names of nominees to these boards, she failed to forward accompanying information or clarification sought, as is required by the Public Appointments County Assemblies Approval Act, sections 4 and 6. Honorable Senators, you have been treated, or at least attempts have been made to treat this House to theatrics by the Governor and her legal team, who, in attempts to deflect the attention of this House from the Governor's violations of the law, have resorted to the stories of gender and other irrelevancies, which are not a sufficient defense or explanation to any of the violations in the impeachment motion. Honorable Senators, as the Governor claimed that she illegally revoked the appointment of the CEO of the Public Service Board based on advice from an unnamed legal advisor. The person who was serving as the legal advisor to the Governor at the time in question came here, testified. Came here and testified that the internal memo dated 23rd February was a forgery. She saw an affidavit that was presented to this House. Honorable Senators, the said memo bears no name, and there can be no clearer indication than this that it is indeed a forgery. In the opening remarks by the Governor's Council, this House was told that the Assembly is lying, and in fact the words used were that the Assembly is made of pathological liars who have believed their own lies. In view of this forged memo, I therefore ask this Honorable House, and I invite the Senators to ask, who is lying? The same Governor who accuses this Assembly, the County Assembly, of lying, is caught forging that internal memo. A ruling was made this morning that she should deliver the original memo. She has failed to do so. The Governor, in the same pattern of lies, stands here and tells you that she has 23 MCAs supporting her. The impeachment motion, a cursory look will tell you it was signed by 49 MCAs. And simple math tells you that 49 plus 23 is 72. Yet, shockingly, the County Assembly of Meru has only 69 MCAs. So it cannot be true that the Governor has 23 MCAs supporting her. The Supreme Court in the Sonko case was categorical that there is no obligation in impeachment proceedings to prove each and every charge, and this means that even one charge substantiated should suffice. In that case, Honorable Senators, guidance was offered that impeachment proceedings are quasi-judicial in nature and are not in the nature of criminal proceedings. They don't necessarily require that criminal culpability should be proven to succeed. All that is required is that these allegations be substantiated. This word substantiate, what does it mean? It simply means to provide evidence. It does not necessarily mean to prove beyond reasonable doubt. It means that there must be substance in those allegations, that they have been proven to have substance. Honorable Senators, as I conclude, the evidence presented before this House cannot be trivialized to statistical count as an attempt was made in cross-examination of the mover. The gender card cannot be used to escape accountability. It is not a carte blanche or a shield to commit impunity. It is not about being female or male. It is about violations of the law and the Constitution. Honorable Senators, finally, in paragraph 7 of the governor's response, that is volume 1 of the governor's document, she seems to suggest that the county government of Meru should be dissolved. I call on this House to reflect on the words of the Bible in the book of Matthew, chapter 18, verses 8 to 9, and to paraphrase the words of Jesus Christ as he was teaching the people then: if your hand or your foot makes you sin, cut it off and throw it away. For it is better to enter the kingdom of heaven maimed or lame than to be thrown to everlasting fire with both feet and hands. There is no cause for dissolution of Meru County. The problem is the governor, and Meru can be saved by removing the governor from office, as the Constitution empowers the County Assembly and this Honorable House to do. Thank you, Mr. Speaker, sir, Honorable Senators, and I pray that you will find that the charges against the governor have been substantiated, and I pray that in keeping with the motto of this Honorable House, for the welfare of society and the just government of the people, including the people of Meru, that you will do the right thing and send Governor Kawira Mwangaza home. Thank you. I invite my senior, Mr. Ndegwa, to conclude our closing.
Thank you very kindly. I must begin by